Today, we're dissecting the crucial legal distinction between admission and confession under Indian law. Let's get started. In legal parlance, admission and confession are often confused, but they have distinct meanings and implications. Both fall under the purview of the Indian Evidence Act, 1872. But while all confessions are admissions, not all admissions are confessions. Let's break it down. An admission, as per Section 17 of the Indian Evidence Act, is any statement, oral or documentary, which suggests any inference about a fact in issue or a relevant fact. It is a broad category and applies to both civil and criminal proceedings. Section 31 states that admissions are not conclusive evidence, but may operate as estoppel under Section 115. Unlike confessions, admissions can sometimes favor the person making the statement. If properly explained, an admission can be withdrawn or explained away. Courts often rely on admissions in contract disputes, consumer cases, and property disputes. Imagine a doctor admits in writing that a surgery was performed without proper consent. This admission may be used against them in a medico-legal case. A confession, though not explicitly defined in the Indian Evidence Act, has been judicially interpreted. According to Pakala Narayan Swamy versus Emperor 1939, a confession must be an admission of guilt in explicit terms or substantially all facts constituting the offense. In short, a confession is an admission of guilt in a criminal case. Confessions only apply to criminal matters. It must be clear, voluntary, and unequivocal. As per Palvinder Kaur versus State of Punjab 1952, courts cannot accept part of a confession and reject another part unless corroborated. In judicial versus extrajudicial confessions, if made before a magistrate, Section 164 CRPC, it's a judicial confession. If made to anyone else, it's extrajudicial and requires corroboration. If a doctor confesses to performing an illegal abortion for financial gain, that's a confession, not just an admission. Courts have repeatedly clarified these principles through landmark judgments. Let's look at some important cases. Pakala Narayan Swamy versus Emperor 1939 defined confession as a full admission of guilt. State of UP versus Deoman Upadhyaya 1960. Confession to a police officer is inadmissible under Section 25 of the Indian Evidence Act. Agnu Nagesya versus State of Bihar 1966. Self-exculpatory statements negating guilt are not confessions. Haricharan Kurmi versus State of Bihar 1964. Retracted confessions need corroboration. Now, why does this matter in medical, legal, and hospital disputes? Here's why. Doctor's admission in a negligence case implies that a doctor's written acknowledgement of a surgical mistake may be considered an admission, but not a confession. In a hospital fraud investigation, if a hospital administrator confesses to fabricating patient records for insurance fraud, that confession can be solely relied upon for conviction if corroborated. In police custody cases, a confession made under police pressure is inadmissible unless made before a magistrate, Section 26 Evidence Act. The law protects against coerced confessions while allowing fair use of voluntary admissions in legal proceedings. If you found this video helpful, don't forget to like, share, and subscribe for more medico-legal insights.